Okay, good morning all. Sorry that we had to make you wait for a while because one batch of speakers is still stuck at our hotel. Some of them got in late, so a bus is just transporting them here. But thank you all for coming and gracing us on this occasion. Thanks to all the speakers, panelists, several others who've come from several cities to be with us today as we debate these very important set of amendments, possibly the most far-reaching set of amendments that we've ever had in our copyright history. And we're very privileged that some of the people really behind these amendments who played a critical role in shaping these amendments are also here with us today and tomorrow to share their thoughts and the insights into what these amendments really mean, how they're likely to be interpreted, and what kind of impact they might have on the future course of copyright jurisprudence and its impact on industry in this country. So I leave sort of the formal welcome addresses later to dear Registrar and to our Vice Chancellor, Professor Bhatt here. But for the moment, what I really want to do is just give you some idea of how this conference, the genesis of this conference, how it originated. So this was an idea from our, we run a law review here called the NUJS Law Review. And the chief editor is the Honorable Vice Chancellor, Professor Bhatt. It's run by a bunch of very dedicated students, and they wanted to do a special issue. They come up with a special issue every once in a while. And this time, they thought that dealing with the copyright amendments might provide good fodder for a special issue of the journal, especially given that we've not had many writings on the amendments since the amendments, and it's hugely controversial. A lot of sections that require a lot of grappling with, and we thought it might be an exciting time to really reflect on the amendments and come up with a special issue of the amendments. And as that idea took root, we started reaching out to people. I think I reached out to Professor Gopalakrishnan right at the start and many others stating that we want to put this together and would you be game? So a lot of them expressed interest. And then we also have a student IP and Technology Law Society here called the IPTLS. And the IPTLS had just finished its selection procedure and selected about 10 students to join the society. And the society's head, the director, Sai Vinod, comes up to me and says, well, we've got a society now, but we need some work. Right? And the easiest way to give work to a society is to do a conference. So we immediately put together a conference and we said, okay, a conference might be a good idea to bring in people to discuss some of these ideas and then hopefully to convert it into papers later that could go into the law review and later into the book as well. And we're very grateful that Sumit Malik, sitting here from the Eastern Book Company, agreed almost immediately to help us with a book publication. So the hope is that this conference would generate papers on the various themes, and those papers would first make it to the special issue of the NUJS Law Review, and then subsequently we would also get it out in the form of a book. And the hope is that book would then serve as a good guidepost, signpost, lighthouse, whatever you want to call it, for courts and for others that are grappling with these amendments and what exactly they mean. Now these amendments, for those of you tracking them, are by and large, by far, the most far-reaching in terms of the impact, in terms of the consequence, in terms of the battles that they engendered. It was a work in progress for almost 10 years, sir? 10 to 15 years. The first draft of these amendments came many, many years ago when Mr. Madhukar Sinha was the Registrar of Copyrights, and he's going to join us later in the day. He's going to be with us on one of the panels dealing with copyright and technology, and tomorrow on copyright and enforcement. So it was during Madhukar's tenure that we had a first draft set of amendments because it was thought that after the later set of amendments in '94 we needed another one, and the first draft was out around 2000, 2001, and then it went through a lot of contests with a lot of people making submissions, various industry groups, civil society groups, either happy or not too happy with the current set of amendments. And then finally in 2000, last year is when we had the amendments finally pass Parliament, after it went through several changes. And these amendments also made it to the front pages of most newspapers, as most of you may have tracked, because it dealt very significantly with Bollywood, right? And anything dealing with Bollywood obviously gets coverage in a big way. So in a way, it was very helpful that our lawmakers decided to focus on Bollywood because it made copyright much more popular amongst the public, right? And for those of you who've seen the latest Bollywood movie, which is called Oh My God, right? You have a scene there where somebody claims a copyright over God, right? Of course, they confuse terminologies. Somebody says, I have a copyright over God, and somebody else says, well, you can't brand God. So two distinct concepts to us IP lawyers, but to the lay population, you sort of subsume them under one category. But we'll leave that aside. At least it's in the public eye, right? At copyright, what it means. People are thinking about it. People are talking about it. It helped that Javed Akhtar was the key force behind a large part of the set of amendments dealing with Bollywood. Unfortunately, he's not, owing to a very pressing engagement, he's not able to be with us today as a keynote speaker. But he wishes me to convey to all of you his sincere apologies, and he hopes that this discussion will pave the way for a lot of future thought and debate on this topic. It's a set of amendments that he personally holds close to his heart, and I'm pretty sure that all of us expect that these set of amendments would be challenged in court, particularly the ones dealing with the Bollywood royalty provisions. And we're not far off from the day when we see many of these things being litigated. So much like, in many ways, like a Bollywood movie, these amendments play their way out, right? I mean, you had a very melodramatic script right from the 2000s when they were first structured. You had various heroes and villains that cropped up during the entire process of lawmaking. Some of those heroes will be with us today and tomorrow. Thankfully, we have none of the villains. I don't know if there are any villains in this piece. A lot of fights, songs and dance, right? Dash of romance, some surprising twists and endings. Section 2M dealing with parallel imports got removed at the last stage. A complete surprise. Nobody still knows why it happened. And you know, it's a conference reflecting on all of this we thought would be ideal, given that now we finally see one piece of intellectual property lawmaking reaching down to the masses in a big way and having more of a public debate than what we've ever seen in the history of IP lawmaking in this country. I mean, these set of amendments engendered more debate than at least I personally witnessed during my entire tenure with the IP field, barring, of course, the patent. I think the 2005 patent amendments did spur up a very heated debate that was on mainstream media and that a lot of the public engaged with. But I think in the copyright field, this is perhaps the one set of amendments that has brought in more public attention than any other in its history. So I want to really, you know, although we do a vote of thanks right at the end, I want to really start by thanking the MHRD, Ministry of Human Resource Development, the Copyright Registrar, Mr. Ravinder. He's going to be joining us soon, for really instituting the chairs and giving us enough support to enable us to do these conferences. So the moment the conference idea cropped up, I realized that our budget wasn't sufficient. So I reached out to Professor NSG, who I've been very fortunate to have as my teacher. So he's been my IP guru for a long time, and I've been a student at the National Law School in Bangalore, and one of the key reasons why I joined academia is also because of his inspiration. So I have much to thank him for. And knowing that one of NSG's key weaknesses is that he can never say no to his students. So I said, sir, I need more money on this conference. I need you to collaborate with me, right? I need you to lend your hand, and so that we can do it on a grand scale. And he immediately said yes. So thank you very much, sir. My Vice Chancellor, Professor Ishwar Bhatt, who's a public law scholar, has done wonderful work around law and social transformation in India. He's got a book on that. He does a lot of work around non-profit organizations, law relating to them. And I thought that IP was not of particular interest to him, but he's been pushing me for a while to do something related to IP within NUJS. Till the time that I sat in with him on a panel interviewing people for the position of an IP research associate, I had no inkling that he was actually a serious scholar of intellectual property too, because one of the unfortunate candidates that came in was asked the question by him, what is Justice Breyer's dissent in Eldred versus Ashcroft? I don't know how many of you know of the case, but Eldred versus Ashcroft, popularly called the Mickey Mouse case, right, was a term extension case where US Congress decided suddenly that Mickey Mouse and various other cartoony characters needed more protection under US copyright law, and you would get more Mickey Mouses if you extended the term of copyright protection. And obviously, as soon as the Congress came up with the law seeking to extend copyright protection, it was challenged in a very heavily fought constitutional challenge in the United States, saying that this was unconstitutional. Right? I mean, as it is, you're giving 60 years plus the life of the author, and now you want to extend it by another 20, 30 years. It really doesn't make sense because we don't know if creators, would create more because you've given them an extra 20 years after the 60 years after they've died. It doesn't make sense, right? It's a no-brainer. But anyway, the constitutionality challenge was lost. The Supreme Court pretty much came up and said, Congress is free to grant as many years of copyright protection as it wants. If it wants to grant 1,000 years, so be it. We can't interfere as the court, right? This is perfectly constitutional. Justice Breyer had a very interesting dissent there, and not many of us read full text judgments. Even fewer of us read dissents. But apparently our Vice Chancellor had read the dissent and had then posed that question to this unfortunate candidate, who I think surprisingly knew the answer, actually. So she got appointed as the research associate. But then I knew that his engagement with copyright was not just nominal, but phenomenal. I mean, a little more in-depth. And so I'm very grateful that he of course, supported this conference wholeheartedly, despite the short notice, and also agreed to open the conference with his inaugural talk. I want to thank our registrar, who's been a terrific strength for the institution. Not only is he someone blessed with terrific administrative acumen, but he's also a very deep scholar. And so when I called him for this conference, his first apprehension was, I know nothing about copyright. And I said, well, you're part of the scholarly community, and the little that I've seen of you, it should be very easy for you to really have insights on this important area that has an impact, on all of us, on society generally. I mean, the impact of copyright on society is being now debated, discussed. A lot of scholars are writing about it, and a lot of people now know that copyright is not just an esoteric subject that a couple of industry magnates and a couple of quirky lawyers deal with, but it's something that impacts all of us in our daily lives. And so he very willingly agreed to come and help us open this conference, and to also warmly welcome all of you. Of course, most importantly, I really need to thank all the students that I mentioned initially, the law review, people who had approached me first, Smaran Shetty and Nimisha, with the idea of really doing a special review. Thanks, a large part of the thanks goes to them because they sort of planted the idea. And then to Sai Vinod and his team at IPTLS for insisting that they needed to be employed as the IPTLS, and they needed a conference as the venue to make them work. So they did a fantastic job. They organized all of this and really put all this together in such a short time. Invited a number of people. Unfortunately, we lost some speakers apart from our keynote speaker, because apparently today is also a very important Supreme Court case dealing with the entertainment sector. And that's in the Supreme Court, and a lot of the speakers had to back out because they're litigating lawyers. I mean, if you look at the schedule, you will see that we've tried to bring in a mix of industry people, lawyers, scholars, NGOs, policymakers, etc. So as to give you a good comprehensive overview of what these amendments really mean from a variety of different perspectives. Because that's what the amendments really are. And you'll hear it from Professor NSG himself, who's been a key architect of some of these provisions and been a key advisor to the government, that these amendments really were really pushing the thin line because it was trying to balance a lot of competing perspectives. And that's what we're hoping to get out of this, generate debate on what those perspectives were. Did the amendments actually arrive at the right optimal balance? What are the key challenges going to be? And which is why we've called it also copyright amendments. Is it a fair balance? Do these balance out competing perspectives? Because IP is not just about one set of interest, as we all know. It's really about a diverse set of interests. And we now also have a large part of public interest coming into the intellectual property debates. And the best law is that one that balances out all of these interests. We'll never get it right, but at least we can approximate somewhere to that position. So with that, I think, that's pretty much what I had to say. May I now please welcome the Registrar, Dr. Surajit Mukhopadhyay, to please give a short welcome address, welcoming all of you to this conference. Sir.
Good morning and a warm welcome to you all on behalf of the National University of Juridical Sciences, the Vice Chancellor, the faculty, the administration, and of course the students of this university. I've always held that the university is not only an institution which gives out degree papers at the end of a 5-year course or at the end of a 2-year course, but a university is an institution that nudges thinking around, impacts upon the way in which we think, and is always at the forefront of what is emerging and what is contentious. And I'm very thankful to Professor Basheer and of course to the Honorable Vice Chancellor for thinking of this, to Professor Gopalakrishnan for coming all the way from Cochin to be with us today. And as Shamnad has already spilled the beans to you, I am no scholar of law, and his way of saying that he wanted me to come here because I'm a deep scholar was to mask the fact that he arm-twisted me onto the stage today morning. I'm curious about copyright not only in the legal sense of the term, but I'm curious because as a society we are a very communitarian society. And in a communitarian society, the basis of living is sharing. And in that society, as it evolves towards more of an atomized, more of a modern contractual society, we of course need things like the copyright because we need to move away from this contractual communal basis of living to a more defined proprietary way of life. And it is in this sense that I felt that the debate on copyright, not only today but as it started, and as it caught the popular imagination through Javed Akhtar, who unfortunately would not be with us today to speak his mind, and in Parliament, to the work, splendid work done by Akhtar himself and all of you who are in the business of law and legality. What I was missing out on this very important point, and this, as I said, was another instance of how a society is evolving from a certain kind of a consensus to another kind of a consensus where you feel that proprietorship has to be rewarded. The second concern is very interesting, and I'm quite sure that you will be also discussing this today and the day after, and this is about work. When you talk about work being rewarded, when Akhtar was talking about songs being rewarded, copyright being given to songwriters, to script writers. We were talking about again a shift, where in our history, the idea of the word katha is to be transmitted to smriti and to sriti from memory and by hearing. As a society which never wrote down much, the idea of the word was to be transmitted. Again, the ownership was communal because people gathered around to hear what the word was to be. As a society which is grappling with modernity, and some would say that we have already reached the stage of postmodernity, it's another interesting thought to see how this idea of the word, from being a community-oriented word, from a thing that is transmitted to memory and through the auditory response of the human, becomes written, becomes enacted by an act of parliament. And therefore, I'm quite sure that there is a lot of intellectual grist, there's a lot of food for thought in the deliberations that we have embarked upon. As Professor Basheer has already mentioned, the credit for organizing this goes to the students who have been tirelessly working towards this. But he has failed to mention of himself, of course, and as humble people, usually we don't mention ourselves, and a large part of this credit goes to Shamnad Basheer, who has been pushing this agenda for a long time, both inside academia and outside, as I believe. And all of them have, for a long time, been at it. We are grateful to the Ministry of Human Resource Development, the Registrar there in MHRD, who will be with us shortly, for their continuing support and patronage to this effort of ours. And I just hope that it is just not one more conference, not one more day or another 2-day affair in the life of a university, that those who attend and those who speak and those who listen go back with the resolve that we continue to work in this area and that we make the university and the intellectual life in and around the university something that one looks forward to. I once again welcome you all to this university, to this 2-day conference, and I'm thankful to all of you for participating and for contributing to this very, very interesting idea of a copyright and the amendment to such. Thank you very much, and we hope to have a very important and productive 2 days. Thank you.
Thank you very much, sir, for those warm words of welcome and for sharing those insights into what copyrights have come to mean. Before I invite the Vice Chancellor, I also have to really thank Mr. Rajendra Kumar here, who's a partner at KNS Partners in Delhi, because again, we found that we were in a slight fund crunch right towards the end of organizing all of this. The budget was just shooting up and the students were getting very worried. So we reached out and he immediately, his firm agreed to do a part sponsorship of the program. We're very grateful to him and the firm for making this happen.